state will have a competent attorney, and they'll have that advantage that an attorney represents for them. If you decide to represent yourself and the result turns out badly, you need to know that you will not be able to complain that you were ineffective as your own attorney in your defense. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more.
Right here, the judge is doing what's called a farada inquiry, basically a formal test to determine whether this defendant actually understands what it means to waive counsel and represent himself. And trust me, judges take this very seriously, because once you go pro se, the court expects you to play by lawyer rules.
And I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs, and I was promoted multiple times as team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility, and I had to learn fast and move fast.
Have you ever studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast, and I only had that job for 3 years.
Notice what the defendant keeps emphasizing here, that he learns fast. But courtroom skill is not about confidence. It's about legal training, procedural rules, evidence standards, objections, jury instructions, and strategy. Learning fast in business does not equal knowing how to defend yourself in felony court.
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s.
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay. And is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yeah, yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and adjust a lot of information?
Yes.
What about your writing ability?
Yes.
Tell me more about your ability to write.
I wrote up all those. I wrote up all those notices. You didn't read them?
You wrote some documents and filed those with the court on 2 separate occasions.
Yes.
I struck both of those filings from the record because.
Yes, but that's the degree that I'm on.
Okay, so how did you compose those?
I wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make a...
And here's where things start going off the rails. The moment someone starts talking about equitable law in a criminal prosecution, judges immediately recognize sovereign citizen rhetoric. Criminal courts do not operate under commercial equity theories, and this is a massive red flag for the judge.
You're telling me now.
Okay.
I'm learning as I go.
Okay. Anyway, so you, along that same vein, had filed some documents with the court. In those documents, you attempted to distinguish between your physical self and a capitalized corporate version of your name, not even your legal name. You understand that the court doesn't recognize that distinction?
No, I do not.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the contrary.
If that's what you're telling me.
Okay. Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me
Oh,
off.
sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
You have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court
I have no problem.
within, say, 10 days.
I can do it today.
And then, well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I gave you the notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
were these charges already filed at that time?
Yes.
You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay.
This is a critical turning point. The judge is basically warning him. If you keep pretending not to understand basic legal concepts, the court may question your competency to stand trial. That's not a bluff. That can trigger a full mental evaluation.
That I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Ferretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana Rules of Criminal Procedure, the Indiana trial rules as they're brought into those criminal procedure rules, Indiana rules of evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. And then I want to make sure you're clear. The United States Supreme Court has made it clear that the right of self-representation is not a license to abuse the dignity of the courtroom, nor is it a license to ignore the actual rules of procedure. Do you recognize that?
Yes.
You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far.
The judge is laying down the final warning here. Self-representation is a right, but it is not unlimited. If the court believes you're using that right to disrupt proceedings, file nonsense, or waste time, that right can be revoked immediately.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you've forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the two attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case. Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law, and I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L v. State of Indiana, and I think that's an adequate Feretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert these proceedings. Defendants utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction, attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings.
And that's the knockout blow. The judge doesn't just deny self-representation, he explicitly finds the defendant is trying to weaponize sovereign citizen arguments to obstruct the case. In legal terms, that is devastating for any future attempt to argue the court acted unfairly here.